Yeah, please, Regularization.
Yes.
I beg to mention item number 31 to 34, which is supplementing this, which is business for admission.
31 to
31 to 34. For admission, which is in the
in the
supplementary
supply
list.
list. Okay, okay.
We are praying for your kind indulgence for upgrade. The issue relates to special recruitment drive of the medical personnel. The written test was supposed to be conducted on 26th of August last year. In view of the interim order, that has not been done so far. In the meantime, 30 posts of doctors, 2 NPSC written exam was conducted last month. In fact, on 26th of June, when it was listed before you, this honorable court, your lordship was pleased that the matter be listed as a fixed item on 14. However, the matter could not be listed and it was listed on 15. On that day, due to some difficulties, the matter could not be taken up. But this court agreed then on the 15 that the matter should be taken up as first item today. However, it comes in the supplementary list.
Oh. Okay, then it can come up after motion,
Much of
after the motion
But-
items. Call after the motion.
Next option.
Yes,
By paper to maintain 26.
26.
For the petitioner.
Yes. 26, yes.
If the matter come up to 2 weeks lordship.
Third learned counsel for the petitioner, Mr. Fusiko. Stop. Learned government advocate, Ms. Chang. Learned counsel for the petitioner is briefed for listing the matter after 2 weeks. No objection?
Lordship,
It is allowed, list after 2 weeks.
So there's an interim.
The interim order passed earlier shall continue till the next date.
Plus one.
members of Lordship,
Yes,
Lordship, I beg to mention item number 22,
22.
Lordship, on
Yes.
behalf of S. Chan. Can you grant 3 weeks time difference the bit?
On behalf of?
S. Chan,
Yes, Chang. Okay. Learned counsel for the government respondents. Ms. Such has made a mention on behalf of Ms. S. Chang, government advocate, to list the matter after
3 weeks.
3 weeks. Okay.
No objection.
The learned counsel for the petitioner is present and has not objected to the said prayer. Stop, list the matter after 3 weeks. Yes,
Similar prayer with item number 23, Lordship.
23. 23 on whose behalf? Same. S.
Lordship,
Chang. 23 also on behalf of S. Chang after 3 weeks. Where's the petitioner here?
yeah, I'm for the bit.
Okay, learned counsel and such present for the petition. Yes.
Lordship, I just like to beg to mention item number 27.
27, yes.
Lordship,
What
can you
happened?
list this matter next week? On behalf of S. Chan.
Next week, okay. On the prayer of the counsel for the state respondents, list the matter next week. Learned counsel for the petitioner, Tushi Longcomer is present and has no objections. Yes. List after, list next week.
Lordship. Lordship, item number 20 also on behalf of AIAB.
Item 20 on behalf of AIME government advocate.
The 3 weeks
Yes,
time difference.
list the affidavit.
Lordship,
This is the matter after 3 weeks in order to enable the state respondents to file affidavit in opposition. Yes. Stop. Learned counsel for the
Affidavit.
petitioner.
The matter regards to disciplinary proceedings, termination. We are actually in a disciplinary proceedings, so if an endeavor may be made to file the affidavit as soon as possible.
Item 20, na?
Lordship,
You're mentioning item 20. It's okay, this is 25 matter, I think. An endeavor shall be made 20.
Thank you.
Yes. List the matter after 3 weeks. What did I say? To enable the government advocate to file affidavit in opposition. Yes. The government advocate shall make an endeavor to file the same by the next date. Yes.
are you blessed? Lordship?
Thank you, so Lordship. Lordship, I beg to mention item number 18.
18.
Lordship, here my senior is recently entered appearance for respondent number 1, Your Lordship.
For R1.
Yes, Your Lordship. So if this matter may be listed after 3 weeks, Lordship.
Learned counsel is such who has made a mention that her senior, Mr.
Ezimomi.
Ezimomi, should be appearing for the respondent number 1 and has therefore prayed for 3 weeks' time. You have not filed your vaklat in order,
Bakalan mo, Your Lordship.
okay, in order to file her affidavit in opposition.
We have filed our report.
File that also.
Just to seek some instructions. Since we're
Just say in order to seek some instructions, list the matter after 3 weeks.
much of it.
Yes. Yes.
Yes, Your Honor.
Mm.
I have to mention item 14.
1-4, yes.
Yes. Sir. 3 weeks to file affidavit in opposition.
Learned government advocate, Mr. M. Longkumar, has prayed for 3 weeks' time to file affidavit in opposition. Learned counsel for the petitioner, Mr. Rainbow, is present. Prayer is allowed. List after 3 weeks. Learned counsel, such and such, appears for private respondent. You have also filed. You haven't filed. Okay. Similar prayer is also made by the learned counsel for the private respondent. Stop. To file accordingly. The private respondent is also allowed to file his affidavit in opposition by the next date. Yes.
That is lordship. Lordship, I'd like to mention item number 14, the admission. Lordship, here the reading is already completed for parties. But I've taken the consent of the parties that if the lordship may be pleased to list this item as a hearing item.
Which one? Which item?
14, lordship.
14, 1, 4,
Lordship, 13, sorry. 13,
13.
yes, lordship.
Yes, 13. What do you want?
The reading is completed.
Reading completed.
Lordship. If the lordship may please list this as a hearing.
Hearing item. Learned counsel for the petitioner, Mr. Armudi has submitted that the pleadings are completed in the present case. Learned counsel for the respondent, government respondent, as well as private respondent 1 are present. List the matter for hearing. When? Usual course.
Yes.
Hearing in usual course. Yes.
Right.
Yes.
Lordship,
Yes.
Lordship, I'd like to mention item number 7 to 12. These are analogous matter
11 to-
pertains to work just preparation of it.
Oh,
State has already filed the affidavit, so kindly grant us 3 weeks time to file the affidavit and reply.
Learned counsel, such appearing for the respondent submits that the state respondents have already filed their affidavit in opposition, and accordingly he prays for 3 weeks' time
Yes,
to file his affidavit in reply. So prayers allowed, list the matter of the 3 weeks. Learned counsel, learned government advocate, and such present for the respondents. Yes. Yes.
For motion, item number 1.
Please, your lordship, your lordship, here, what the petitioners number 1 and 2 are seeking for regularization of service. As they have retired after serving for 35 years of service under the establishment of the executive engineer PhD. And they have served the representation with the chief engineer also PhD on 25/6/2025. However, your lordship, there is no response from the respondent department. Therefore, the petitioner before this honorable court.
Who's appearing? Yes. You have accepted notice.
Lordship,
Can we dispose it off? To consider in view of the OM dated 17/3,
lordship, okay.
or you want to get some instructions?
Lordship, yes.
Next week, next week.
Lordship.
Third learned counsel for the petitioner, Ms. Such and such. The petitioners herein are seeking regularization of service. The petitioners herein are work charge, we're serving as work charge labor. We're serving as work charge labor, and have retired on 31/8/2024, and the other one, 21/3, 21, no. No, one is 31/8/2024
31/12/2021.
and 21/3/2000. 21/3/2000.
Your lordship, petitioner number 2 is retired on with effect from 31/12/2021. Petitioner.
Oh,
number
okay,
2.
okay. So one was 31/8/2024 and one is 31/12/2021. Stop. It is stated that the petitioners were eligible for service regularization as per the office memorandum number AR-3/GAN-201/2009 PT and the bracket dated 17/3/2015 as they had already served for 35 years. Stop. Issue notice to the respondents number 1, 2, 3, and 4. Stop. No formal notice is called for as the no formal notice is called for as the government advocate such and such has already accepted notice on behalf of the respondents. Stop. List the matter after 1 week. On the next date, the government advocate shall get instructions as to whether the case of the petitioners can be considered under the said office OM dated 17/3/2015. And an effort shall be made to dispose of the same on the next return date. This after 1 week.
For motion, item number 2.
Your Lordship, here also the same prayer is sought. However, here, Your Lordship, petitioner number 5 is the wife of the deceased retired employee, Your Lordship.
Hmm.
The prayer is same,
But in
the department is
but-
different.
okay, but in case of respondent number 5, it is the wife.
Petitioner number.
Petitioner's
Wife of the.
the wife of the
Yes,
deceased work
yes, Your
charge. Learned counsel for the petitioner, MS such and such. In the present
There are
petition.
details in my paragraph 2. Details can be found in my paragraph 2. I have prepared in tabular form.
Okay. Yes, the petitioners herein were serving, the petitioners number 1 to 4 were serving as work charge employees and had been released from service on completion of 35 years on 30/9/2020, 31/3/2021, 31/10/2022, and 31/10/2022. Stop. The wife, the petitioner number 5 is the wife of the deceased work charge employee, namely
Bishop.
Shri
Sri
Pishau, Shri Pishau, P-A-S-H-O-U, okay, Shri Pishau, who had also been released on completion of 35 years of service on 30/4/2024. Stop. The petitioners herein are praying for regularization of their service in terms of the office memorandum number AR-3/GEN-67/2001 dated. Wait. It should be 17/3 actually, no, 17/3/15. Sorry, just delete. It should be OM number AR-3/GEN-201/2009 PT in brackets dated 17/3/2015. Stop. Issue notice. This one, it needs some instruction.
Yes, sure.
Issue notice returnable within 4 weeks. The learned government advocates and such has accepted notice on behalf of respondents number 1 to 5, and therefore no formal notice is called for. Stop. However, the counsel for the petitioner shall supply extra copies of the petition to the government advocate during the course of the day. Stop. List the matter after 1 month.
Okay.
4 weeks. Yes.
Right.
For motion, item number 3.
Well, leadership, this is a bit challenging the demand notice phase under the PF Act for the new management of petitioner. So leadership petitioner number 1 is the new management of petitioner number 2. Petitioner number 2 is Nagaland.
Such a long synopsis.
Your leadership. But it's a very small matter, your leadership. Your leadership petitioner number 2, Nagaland Pulp and Paper, was a subsidiary of Hindustan Paper Corporation, a government of India company. Now the HPCL, Hindustan Paper, went into liquidation in 2019, your leadership. It is still under liquidation pending before the learned NCLT Delhi. Your leadership, in the meanwhile, the liquidator of HPCL floated the auction for of its shares held in NPPCL, petitioner number 2. After 20 different advertisement, in the last attempt, petitioner number 1, a private company, participated in the auction and bought these 96% shares, and therefore became the management of petitioner number 2, NPPCL, the company. Your ladyship, thereafter, a demand notice was raised over the new petition, over the new management, saying that 2009, 2010, there is some PF obligations that are pending. Now, your ladyship, this PF obligations do not pertain to the principal amount. These are penal damages and penal interest that were pending. Your ladyship, there are judgments which says section 17B. If your ladyship will just come to page. Your ladyship, to page, just a minute. Yeah. I beg your pardon, your ladyship. Trying to find the section.
Actually, this is in respect of
Your
that
ladyship,
erstwhile to Lee paper mill.
Indeed, your ladyship. Page 18 of the petition, your ladyship, we have reproduced 17B of the EPF Act. It talks about scenarios wherein a management is transferred. Your ladyship, liability in cases of transfer of establishment, where an employer in relation to an establishment transfer the establishment in whole or part by sale, gift, so and so whatsoever, the employer and the person to whom the establishment is so transferred shall be jointly and severally be liable. So, your ladyship, the old management as well as the new management will be jointly and severally liable under 17B, and under the same section, this section has been invoked to bring the obligation over us. But your ladyship, there is a catch to it. On the first word, where an employer transfers, your ladyship, this word employer has been interpreted in 17 in relation to 17B only, wherein a change of management takes place, saying that a transfer by operation of law will not mean that there is a transfer under 17B and the old management is liable. Your ladyship, I have a judgment, your ladyship. It is part of synopsis also, and I have the full judgment if your ladyship is ready.
Okay, let's see.
This is of Odisha High Court, your ladyship. There are several judgments to this effect, but this is the starting judgment, your ladyship. In this case, your ladyship, Odisha State Financial Corporation has seized an establishment and thereafter they have auctioned it and sold. Your ladyship may come to paragraph 6 of the judgment, last page, your ladyship, second last page, your ladyship.
6.
A conjoint reading of the provisions, section 2A and 17B of EPF Act as quoted above gives a clear picture that the liability to pay contribution and other sums due from the employer on transfer of the establishment is specifically provided in section 17B, it's not 7B, your ladyship, 17 of the EPF Act. The principle behind it is that the employer who is liable to pay under section 6 of the act, the contribution and other sums cannot by the reason of its owning or occupying the establishment on transfer be permitted to avoid such liability. And therefore, the provision made under section 17B of the act that the employer as well as the transferee shall be jointly and severally be liable to pay the contribution and other sum up to the date of transfer. This speaks that by the reason of transfer, the liability of the employer would not cease but would continue so and so. Your ladyship, a few lines below it, the transfer. The transfer by the employer
is
the transfer by the employer of the establishment contemplated under 17B is an act of by the employer. Here is a case where the transfer has not been made by the employer, but after the seizure of the unit establishment, the same was transferred by OSFC to the present petitioner. There is no indication that 17B contemplates transfer otherwise than the transfer by an employer as defined under EPF Act in relation to the establishment. By a court sale or otherwise, a transfer takes place by operation of law and not by any transaction interviewers. In that sense, it is an involuntary sale against the wishes of the person whose property is sold. That can hardly be understood, ordinarily understood. That can hardly be transferred ordinarily understood, which connotes a voluntary transactions entered between two parties. Now, your ladyship, this judgment has been quoted even by
What is OSFC?
OFS. It was a Odisha State Financial Corporation. It was a kind of a
Transfers by the OFS to the.
which would give loans to companies, your ladyship,
Okay,
if I'm not wrong.
Okay.
Now, your ladyship, this judgment has been quoted by Bombay High Court. This judgment has been quoted by the Honorable Punjab and Haryana High Court. In cases where a liquidator sells the property, in cases where by way of mortgage a property is being sold, and it is said that the penal damages will not be fastened over the new management if it has been transferred by operation of law, which is the exact case in our scenario. The official liquidator of the parent company, by way of an e-auction monitored by the learned NCLT there, has sold this, has floated these shares, auctioned it, we came and we purchased these shares. Now, your ladyship, these PF liability pertain to 2009, 2010. At that time,
2009, 10.
indeed, your ladyship. Even at that time, your ladyship, this petitioner number 2, the Tuli company.
And you took over when? You took over when?
We took in 2023, your ladyship.
23.
2023, 2024, at the end of 2023, your ladyship, because the advertisement under which we came is annexed, your ladyship, at page 63, your ladyship. The date is 4th of October 2020. Page 63.
Page 60.
63. And it's your sheet. Your ladyship will see at the top, sale notice of assets of Hindustan Paper Corporation in liquidation.
Which means, okay.
And this has been floated by the official liquidator of the company, your ladyship. Now, these are the shares that we bought, and ipso facto, we became the new management of the company. The principal amount has already been paid. All of your ladyship, I'll bring you to the impugned notice. At page 64, your ladyship, is the notice and the show cause notice.
So the dues were of, where do I find that it's of 2000?
Indeed, your ladyship, after this, we sought a clarification over the date. The letter of clarification is at page 65, which we had written to the department. And thereafter, your ladyship, on page 67, they issued a clarification. Clarification subject, clarification regarding the recovery notice dated 6/5/2025. If your ladyship will come to paragraph 2 of that.
1 minute. 60. Yes,
Paragraph 2, ladyship,
yes,
the amount so and so.
is related to penal interest and penal damage and such and such. Okay, from 6/2009
Indeed, your ladyship.
to 2012.
While I was not in management, a certain amount was already deducted. That has been written of 70 lakhs something. Your ladyship. And the balance amount they are asking from me. Now, your ladyship, the parent company is still under liquidation. And in various such cases, the Honorable High Courts across the country have given this order that you are free, the department is free to raise this obligation with the parent company or the erstwhile management. But the new incoming management will not be fastened with these penal liabilities. your ladyship. And there's also an additional fact to this. Your leadership, initially, this is the second time this same demand notice or we were over the same issue. The company, NPPCL, the Tuli company has approached this honorable court. Your leadership in 2016, while the parent company was still alive, this company was declared a sick company, a sick company. Your leadership by in 1999 itself, it was declared a sick company. Thereafter, your leadership under the Sikh Companies Act, your leadership at that prevailing at that was SICA, and under the EPF Act, there was a leniency given to these companies that the principal would be charged, but these kind of penal damages would not be charged. Your leadership, that was a proviso in 14 clause B. Your leadership, using that proviso, the company has approached this honorable court. This honorable court has held that the revival of companies also, we understand that your leadership, I'll just read. This is at page.
The earlier owner had also come before this court. The earlier company.
Your leadership, at that time, the
That
company
time.
was the owner had not come. The company in its own capacity had come, saying that I am declared a sick company. Therefore, under the provision of law, you cannot charge me with penal damages because the law prohibits so. Your leadership will come to page 42. This is the judgment of this honorable court in 2016, your leadership. The first page of this would be. It starts at 29, your leadership. Actually, 28, your leadership. I'm sorry. Now, your leadership, all the factual aspects were discussed in this. This was about the same time period, the same DF notice.
This was filed by NPPC.
Indeed, your leadership. If your leadership will come to paragraph 42.
Paragraph 42.
I beg you, page 42.
Page
your leadership.
42. Yes.
The second last paragraph. From the record, it is clear that the NPPC is a sick company and is being referred to BIFR and is in a revival process under the sanction scheme. As such, all claims and dues are to be settled through BIFR. No doubt, the PF Act is a welfare legislation and meant for weaker section, and therefore the due accrued towards the provident fund are liable to be paid by NPPCL. However, I am of the considered opinion that it is necessary for this court to look into the larger public interest without, of course, compromising the interest of weaker section. When NPPC is still under revival process, if the impugned order issued by the respondent are given effect to, it will definitely have adverse effect on the revival process of NPPC, which will not be in public interest. Therefore, this court is of the considered opinion that the impugned order needs to be interfered with. And thereafter, your leadership, 5 notices where it was directed that the department will not give effect to these notices, but will take it before the BIFR board. What happened after this, your leadership? This is a judgment of January 2016. By December 2016, the SICA Act got repealed. And all the proceeding before BIFR were stood abated with a clause that if within 180 days under the new Insolvency Act, if the company files for voluntary liquidation before the learned NCLT, then the matters will be revived. Otherwise, it will not go. In all fairness, your leadership, I'll also inform that this judgment was appealed before the learned division bench of this honorable court by the department, and the division bench reversed this judgment on the ground that now SICA has been repealed. It is just the next page, your leadership, 44. No, I beg your pardon. This is the typed copy. The division bench judgment is at
Page 58. I think.
58, your leadership. Annexure 2. Paragraph 3 records that resolution. And thereafter paragraph 6.
Paragraph 6. So
So,
it
on
became
the-
infructuous.
Indeed, Your Ladyship, only not on merit, Your Ladyship, but because the act does not
Because it
stand
was
for it,
repealed.
there is no provision of BIFR, so there is no way the 2016 judgment could be effected.
Okay, we'll issue notice at this stage.
Only a last point, Your Ladyship.
Yes.
Page 69,
Hmm.
the department has been the department has already attached my bank accounts. Page 69, Your Ladyship. This is 1st of July this year, Your Ladyship. They have written it to the bank.
Reducing. What is the total amount
Your Ladyship, the total amount to be paid as of
to
now
be paid?
2 lakh,
2 crore, 2 crore,
crore.
40 lakhs.
Yeah, indeed, Your Ladyship.
2 crore, 40 lakhs.
2 crore 4 lakhs, Your Ladyship.
Yeah, 2 crore, 4 lakhs, 3,283.
Because 70 lakhs were already deducted when I was not brought in the company, and we are not agitating that. We are only agitating from the point I was brought in the company, because 17B does not apply to.
Then why here in this letter at page 69, they have written different figure, 1 crore, 94 lakhs. What is this?
Your Ladyship, I believe that indeed, Your Ladyship, because there are even possibility of arrest and stuff. We were instructed today morning by our client that some amount, I think around close to 8 lakh or 9 lakh, to under protest, but just to show our bona fide, were deposited with the PF officer, Your Ladyship. Because Your Ladyship, it entails arrest and other provisions of the directors also in case an attachment of Your Ladyship. They are trying hard to revive this company. There are talks going on with the government to revive the agreement and revive the company. So Your Ladyship, any kind of attachment will have very severe effect over the revival as well as over the safety of the directors who sit in Bombay, Your Ladyship. So under those conditions and under protest, they have deposited a certain amount.
That's why it came down to 19.
Indeed. Sure. With a hope that in case we win this case, that may be adjusted to our future PF liabilities.
How much time have you been given here in the notice?
7 days, Your Ladyship.
7 days.
This was 6th of May, 2025. We were asked to pay within 7 days. Thereafter, the officers of the company visited the UPF office, had some deliberation, took out the clarification. So till now, it is under control, Your Ladyship. Nothing adverse has happened, but we fear for the future, Your Ladyship. That's why we are also praying for a stay over the demand makers until this rate is decided.
This petition has been filed by the, what is the name of the, by the MS 3A Capital Services Limited through its authorized representative, praying for quashing and setting aside of the impugned recovery notice letter bearing number REF.EPFO. You just check out from the prayer portion, okay, later. /SSO/DMR/NEGHY// dated 6/5/2025, issued by the Regional PF Commissioner Roman 2, Compliance and Recovery under bracket. and recovery notice number such and such, and recovery notice number such and such dated 27/9/2022, and recovery and attachment order number such and such dated 1/7/2025. Stop. I've heard learned counsel for the petitioner, Shri such and such. Please give your name. Stop. It is submitted that the petitioner is the new management of the Nagaland Pulp. What was that? Nagaland
Then Pulp and Paper
Pulp and
Corporation.
Paper Corporation. Stop. It is also stated that they had acquired the shares of the same only in the year 2023. Stop. The NPCCL was under the management of One Hindustan Paper Corporation Limited earlier, which underwent liquidation, and thus by operation of law, the official liquidator had floated the e-auction for the sales of NPPCL, which was acquired by petitioner number 1. No, earlier I said Nagaland Pulp and Paper, and then you say in the bracket NPPCL for short and close the bracket. Then, which was acquired by the petitioner number 1. Stop. The petitioners have challenged the demand notice dated 6/5/2025 raised by the respondent number 1, EPFO, under section 14B and 7Q.
Yes.
Yes,
Would be respondent number 3, I guess.
Two.
respondent 2. Okay, respondent 2. Under section 14B and 7Q of the Employees Provident Fund and Miscellaneous Provisions Act 1952. On the bracket referred to as the Act of 1952. Okay, stop. It is stated that the impugned demand notice pertains to the Provident Fund obligations of petitioner number 2 for the year 2009-2012. Moreover, it has been clarified that the present dues are only towards interest, as the principal amount of the Provident Fund demand has already been cleared. Stop. The petitioner states that the petitioner number 1 was never the employer under section 2E of the Act at the relevant time of which these penalty charges pertain to. Stop. It is also submitted that it is settled law that change of management of an establishment under section 17B of the Act is confined to only willful transfer and not a transfer which is effected by operation of law. Stop. Next para. Issue notice to the respondents number 1, 2, and 3. The petitioner shall.
We have
Oh, okay. Delete. You just say respondent number 1 has been represented by the learned CGC, Mr. Yangarwati. Stop. The petitioner shall take steps. Before that, you say issue notice returnable within 4 weeks. Then continue. Petitioner shall take steps for service on respondents number 2 and 3 by registered post, as well as usual process within a period of 3 working days from today. In the interim, the impugned only annexure P4, isn't it? Annexure P4 can be state that will serve
And
your
you
purpose.
check the 1st of July letter of attachment at page 60.
Page
69.
69.
Your ladyship, that is in continuation of the 2022 attachment, which is at page 68.
Please.
That was the original attachment.
Yes.
Your ladyship can state that only or.
No, if
up to date.
6/5/25 is state,
Indeed.
I think that will do, or
But your ladyship.
and 1/7 and 1/7.
As your
6/5
ladyship,
and
we just
in the
have
interim, yes,
content
in the interim, the impugned notice number such and such dated 6/5/2025 and the impugned recovery notice
attachment. notice.
attachment notice number such and such dated 1/7/2025 shall remain state. Stop. The respondents are at liberty to approach this court for modification slash vacation if so advised. The list of the forwards.
I'm very grateful to you, chiefs.
For motion, item numbers 4 and 5.
May I please your lordship, please? Your lordship, this IAS filed for striking out the name of the petitioner number 30, that is C. Pukam K. From the present writ petition, it is 172 of 2024. Since the said writ petitioner number 30 has been duly requested by different counsel in different writ petition, that is WBC number 155 of 2022, my lord.
Oh, then how you put his name also?
Your lordship, the thing is that the petitioner's counsel was not aware of the previous proceedings.
Mm.
And only after receiving from the petitioner number 30,
Mm.
we have come to know that the case has been duly represented by different counsel, my lord.
Mm.
So your lordship, in order to avoid duplication and multiplicity of proceedings, his name may be removed from the present petition.
Yes, he's already the petitioner in WPC 155, isn't it?
Yes, your lordship.
Who's representing? You are representing. Okay. So you have no objections? Mm. This IA has been filed by the petitioner praying for deletion of the name of Shri C. Pukam, Pukam Kongyak, Sri C. Pukam Kongyak from the list of petitioners as he is appearing in the cause title as petitioner number 30. Is petitioner number 30. It is submitted by the learned counsel for the applicant that the present applicant along with 48 others had filed WPC 172/2024 on 24/6/2024. Stop. However, it has come to the knowledge of the petitioner's counsel that the petitioner number 30, being C. Pukam Kongyak, had earlier filed a writ petition being WPC 155/2022, which is pending before this court. Stop. It is stated that the inclusion of the name of Mr. C. Pukam Kongyak in the present writ petition had been made without the knowledge of the previous proceedings. And the petitioner's counsel was not aware about the existence of WPC 155/2022, which was pending before this court. Stop. Accordingly, it is prayed that the name of the petitioner number 30/C Pukam Kongyak may be deleted from the array of petitioners. Stop. Learned government advocate, Sergeant Such, yes, and learned counsel appearing for C. Pukam Kunyak in WPC 155/2022 are present and have no objections. So accordingly, the IA is allowed. The registry shall take steps to strike out the name of Shri C. Pukam Kunyak from the array of petitioners in WPC 172 of
2024.
2024. Stop. The matter is accordingly disposed of.
Obligement, please.
From the supplementary cost list for admission, item numbers 31 to 34.
Yes, sir.
Yes.
Lordship, I'm put the petition and item number 33.
In 33.
Item 33.
So which one do we take up first
Lordship,
or?
Lordship, in this page of big petition,
uh,
Lordship, I'm challenging the minus of the cabinet, which was issued on 7 August 2024.
hmm,
Approving for regularization of COVID-19 appointees through a departmental screening committee.
This is 187, WP 187.
239.
Okay. This is another petition with lots and lots of pleadings.
Here, 3 of affidavit as well as the reply.
Okay, so this is
Yes, Lordship,
39.
in June approval is at page number 144 in my read. Lordship,
Okay, you're challenging this.
I'm challenging this. Lordship, I'm challenging this on the ground that Lordship, my read petition is concerned with the post of medical officers.
Hmm.
Lordship, is a department, they have already framed a service rule.
Hmm.
That is Lordship, Nagaland Health Service Rule 2006. As per the rules of 2006, the post of medical officers has to be filled up through the MDC.
May I please, Lordship?
Yes,
Before
yes.
my learned friend does make his submission.
Hmm.
Lordship, kindly allow me to highlight the 4 cases so that which case to be taken up first,
Yes,
which will be taken up
yes, yes.
subsequently.
That's what I want to
Lordship,
know.
the state government appointed certain critical personnel during COVID.
Hmm.
Thereafter, a policy decision was taken to extend relax the rule and one-time dispensation for special recruitment drive,
Hmm.
which is challenged by the petitioner
Mm.
for medical officers in item 32 on the ground that it is in violation of the service rule.
Mm.
And there's an interim order staying the process with regard to
Staying
medical
the
officers.
process. Hmm.
One. Then item 34
Mm.
relates to the petitioners are the research scientists who were also appointed by the same cabinet decision.
Oh,
On the contrary, thereafter,
The research side is not covered,
No,
not covered by the
kindly-
service rule.
kindly allow me to highlight the 4 so that we will decide which one we take enough first and just highlight that point only so that his lordship will not be.
they are not medical officers.
They are not medical officers, they are research scientists. And in view of in view of the pendency of the case and for various pressures from different sources, the examination to be held on 26 was deferred by 2 weeks.
Hmm.
And thereafter, no exam has been conducted so far.
Hmm.
So the research scientist has filed this writ petition.
This
Seeking a
307.
prayer that the SRT should be conducted in terms of the cabinet decision.
Hmm.
Then, Lordship, item 31.
31.
Item
Yes.
31 are medical officers
Hmm.
who were appointed during COVID and who have gone for further studies. Now, one of the condition in the appointment for those during COVID was that they should not go for study leave, they should not take study leave for 2 years. But he went on study leave. So he become ineligible to appear for the SRT. So they have filed this petition, making a prayer that he should be
It
included
should
in
be
the SRT.
included.
Then Lordship, item 30 relates to dental surgeons.
For inclusion in.
One of the petitioner,
Which one is dental surgeon?
item
32.
it is the plea of the petitioner that he's a senior most, he's eligible to be considered to appear the SRT, but for various reasons, he was left out. Calling letter was not issued to him, he was left out from the SRT, so he is praying for inclusion in the SRT. So Lordship, item 31 and 32 is subjected to the outcome of item 33 and 34. Once item 33 is decided, whether the SRT will be held for medical officers, the same service rule governs item 32. So that will be automatic. Then Lordship, item 34 is related to, is a different, the only difference for item 33 and 34 is item 34, there is no service rule. Only the service rule governs the service conditions of medical officers.
Only the
in
medical
dental surgery.
officers.
Yes. So if 33 and 34 is decided first, then the outcome of these two will have a direct bearing on 31 and 32. So we can take up the
Yes,
three
yes.
first, then 32 draft.
Yes, then in that case, I think 33 should be
Yeah,
taken up
33
first.
should be heard.
Uh,
Item number 34. It should not, since it is not covered by the service rule, it should not be heard along with 33.
Then why it was clubbed up?
On the submission of the state council, it was clubbed up in our absence.
Not maybe because it all relating to SRT. So that must be the reason, but we can split at the time of hearing.
I think it's
The sole conditional merit petition is. The purpose of medical officers is governed by statutory rules. So in violation of the provision of statutory rules, this cabinet approval is not sustainable. That is my case. So item number 34, this should not be, since it is not covered by a service rule. This item number 34 should be heard separately, not along with item number 33. It will confuse us.
And in 239, who are you? You were?
We're a fresh medical graduate. Yes, sir.
Okay.
Annexure E, which start from page number 46. Here, page number 10109. These are the past certificate of the petitions. And with regard to your divisional qualification, there's no dispute. So I'm not referring to that. Become the page number 106.
239.
Lordship, in order to effectively tackle the COVID-19 pandemic within the state.
Actually, wait, service rules are here.
Lordship, service rule is not your lordship. I'll provide a service. In order to effectively tackle the COVID-19 pandemic within the state, lordship, the state cabinet on 1st June 2022 has approved this. And the only relevant in here the state cabinet has approved for several action. The relevant is page number 5 with the present case. The requirement of medical personnel like doctors, nurses, etc. was agreed in person. The formal proposal will be submitted by the department for approval of the cabinet appointment. This is an approval accorded by the state cabinet. The other approvals are not related to the present dispute.
Okay.
Chief, in terms of this approval, which was issued on 1st June 2022,
Mm.
the department has submitted a proposal that was considered by the state cabinet, and on 11 June 2020, that is the next annexure, page number 106 or 108. These are minutes of the cabinet held on 11 June 2020. Worship, agenda number 1, we're concerned.
Mm.
May I read?
Yes,
Agenda number 1.
please read.
Appointment of doctors and nurses under Health and Family Welfare. The cabinet considered the proposal of the Health and Family Welfare Department and deliberated in details in the backdrop of COVID-19 pandemic. The department explained that there is severe shortage of doctors and nurses in comparison with IPH's norms, which is 23% as against 50% in case of specialized doctors and 28% as against 75% in cases of staff nurse. As per IPH norms, in that the department was unable to provide required number of doctors in district. Further, in view of the large number of positive cases being reported in many districts, deployment of additional doctors and nurses is required for containment and treatment facilities. In view of the prevailing extraordinary situation, the cabinet having considered the view of the beginner department, including related Honorable High Court judgment dated so and so and so and so, and the financial implication, reviewed the urgent requirement and decided to approve the proposal of the Health and Family Welfare Department as follows. Lordship, the present petition concerns with item 1 and 2. Creation of 53 posts of specialist doctors for 11 district hospitals in the state. And creation of 1 post of Lordship, we are concerned only with item number 1.
Item 1. Mm. And what are these High Court orders dated 3/8/18?
High Court order dated are for just Lordship for
Lordship,
upgrading the medical facilities in the state.
Lordship, kindly allow me to intervene here.
Mm.
I was my case in the Sumutu PIS during COVID. So in view of the shortage of doctors, there was a direction of this honorable court for creation of posts.
Okay. So in pursuance of that, these
Yes,
posts.
this came out. And should we come to page number 109, the last part.
So creation of 53 posts. Okay. Yes.
The cabinet further directed that this approval is one-time relaxation of laid-down rules in procedure for recruitment. It speaks about relaxation of laid-down rules in procedure for recruitment.
Mm.
Regularization and condonation of further this one-time measure in view of prevailing situation in the backdrop of COVID-19 pandemic shall not be treated as a precedent.
Mm.
And Lordship, we come to the next, again, the further approval, which is page number 1102. Again, the cabinet has approved further creation of posts with by framing some certain terms and conditions for the appointment. This cabinet approvals was on 23rd June 2020.
Mm.
Lordship, the first hearing is on the same condition. And item number 1 and 2.
Mm.
Creation of 15 posts of senior specialized for the following community health center CHs.
So another 15.
Yeah, another membership, but the more relevant will be item number 2.
Mm.
Creation of 44 posts of medical officers for the district hospitals.
And 40 pages.
The first and second approval. In the first approval, there is no laid down terms and condition.
Mm.
In the second approval, page number 111. In the top, the cabinet further directed. Lordship, we are concerned with A and B. Here, the cabinet framed some guidelines, some terms and conditions regarding the newly created posts. All the newly created posts should be filled out by the Health and Family Welfare Department within a month's time with proper advertisement. While filling up the posts, due weightage should be given to the marks obtained by the candidates in the qualifying degree of the university, medical college, and years of work experience. The interview panel should include independent experts from outside the state. Clause B, Worship. The department should clearly indicate that all status appointment will be temporary and regular recruitment shall be conducted through special NPC recruitment drive. This is the main condition.
This is 25th June. So in the first memorandum, 53 posts were created. Then by this second one, another
44.
44.
This is the present decision relates only medical officers who are not concerned with the junior specialist.
Yes, it's medical officers. Yes.
And in terms of the cabinet approval,
Mm.
the state government by a notification dated 2nd July 2020, that is at page number 112,
Mm.
was pleased to notify the person of posts.
Mm.
And received again by further notification. The guideline has been framed for filling up the newly created posts. Page 113.
112 and
No, 112.
112 is
112
the.
is a notification
the
about the creation
creation.
of posts.
Mm.
And by page number 112.
But here they have given only 44.
Only 44. Here, only 44.
Mm. Two, 7, 20. Then
And also become the page number 113. This is a notification dated 3rd July 2022. The state government has framed the guideline
mm,
for recruitment of the newly created posts. You see, this is similar with a condition which has been laid down by the state cabinet.
that earlier condition.
Yes,
Yes,
it's
yes.
not, I'm not repeating it.
Mm.
And also become the page number 114. As directed by the state cabinet, the department has issued a recommendation for filling up the newly created posts.
Mm. It is for 8
First, 2020.
2020. Medical
In
officer.
reference to the earlier cabinet approval, so I'm not reading, but
Mm.
we are concerned with the detail of posts. That is within the chart at serial number 2. Medical officers, 168 posts. Here it cannot begin 160 posts of medical officers.
Medical officer 168. How it became 168?
Worship, as per the statement by filed, as per the statement given by the state respondent in the affidavit.
Mm.
Actually, this was the 160 posts. But some refused the offer of
Mm.
appointment.
Mm.
And some failed to continue, even though they accepted, they discontinued.
Mm.
So in the immune approval,
Mm.
during the issues of immune approval, there was only 94 active in service.
Mm. Okay.
And also become the page number 116 in the advertisement. This is the terms and condition which has to be considered by this renewal post. Page 116.
116.
This is the terms and condition laid down in the advertisement. And your contract appointment will be covered by the terms and condition laid down in this advertisement. Page number 116 in the top, terms and condition.
Mm.
Nature and duration of temporary appointment. The appointment will be on temporary basis for a period of 12 months or direct recruitment through NPC, which you raised later. Number 2, the appointment shall have no right to claim for regularization of the temporary service on any ground whatsoever. They accepted these terms and conditions in the advertisement and they appeared in the interview and they were selected. Accordingly, the selection was conducted since it was during the peak of the COVID-19 pandemic. The selection was conducted through Zoom. And they were appointed by serial orders. One of the appointment order is at page number 120. Make sure H. This is 12 November 2020. There should be some relevance to be considered as per the contents of the appointment. So there should be a read.
Shoot. Yes.
Order dated 12 November 2020. As approved by the Cabinet, White Memorandum number so and so, for creation of posts and engagement on temporary basis. In the interest of public service, with reference to recommendations submitted by Directorate Letter number so and so, and with a view to effectively tackle the present pandemic of COVID-19 in the state. The Governor of Nagaland is pleased to engage, the word may be taken into consideration, to engage the following person as medical officers in the pen matrix so and so so and so. And Lordship may come to page number 121. This is the terms and condition of the appointment which they have accepted. And they are still in service on the terms and condition laid out in this appointment. Lordship, just below the name, start from number 2. The engagement shall be as per the following terms and conditions. The engagement shall be for a period of 12 months only, or your regular appointment is made through ABC, whichever is earlier. The clause 2 is very important. The appointee shall have no right to claim for appointment of the engagement on contingency basis, on any ground whatsoever. So you are engaged on contingency basis. You are not appointed on regular basis.
For a period of 12 months
For a period
or
of
till
12 months till the interview is conducted by the ABC.
Yes.
The state respondent as well as the private respondent number 19 to 101. They have taken the ground in their affidavit that we have no locus to challenge this recruitment. When your appointment is on contingency basis, not on regular basis, the post held by them is open for open advertisement even at this stage. So we have locus to challenge. Proceed. After I complete my submission, I will place a judgment on that. From page number 120 till 125, this is the appointment order. Under the same terms and conditions.
Page 122 also, an extra I also.
This is also their
Appointment.
Your appointment by separate order.
Okay. Mm, 123, another appointment order. What is 123?
So all those are appointment orders.
Page 123 also.
Just appointment order. Up to page number 125.
These are the appointment orders of the respondents.
Of the person.
Till 125. Okay.
And Lordship, in respect of the private respondent number 4 to 18. Here are the contract appointees in the department who were appointed during the period 2012 to 2016. That is before coming off
before
the
COVID.
And the cabinet approval, it specifically states about regularization of COVID appointees.
Respondent number?
Respondent number 4 to 18.
4 to 18.
On earlier occasion also, the approach is honorable court by filing a writ petition. bring for consideration of the case for declaration in terms of the policy framed by the state government.
Hmm.
This honorable court declined to grant immediately. The final review was noticed, even though the department considered the case for declaration by this review approval.
They were
By-
appointed during 2012
2012 to 16,
to
on conflict basis.
and they had approached the court earlier.
The earlier enforced report earlier, the petition was dismissed. And now the department has a special case for demolition. Now they have plugged up your case with the COVID administration.
Okay.
Yes, will the private respondent number, private respondents, you were in active service. Your Worship, in the year 2022.
Hmm.
In terms of the approval which was accorded in the year 2020 by the cabinet.
Hmm.
Your Worship, the department, they have submitted the cabinet memorandum. The cabinet memorandum was not with me during the time of filing this petition.
Hmm.
However, the state government in their David brought the cabinet memorandum. Worship, let me refer to the affidavit filed by the state response. Response number 123. Affidavit of response number 123.
Hmm.
Worship, can you come to page number 14?
Wait. This is affidavit and reply. This will take some time. Just wait. Yes. Page.
Page 140, page number 14.
Hmm.
The last, you see the previous models, you were appointed as on 17 May 2021.
Hmm.
So we're given continuous series. The department has submitted this cabinet, prepared and submitted this cabinet memorandum.
Hmm.
This is 1st May 2022. What was it? 13 May 2022.
13 May. Yes.
13 May, as per the statement made by the state.
13.
Which is the contents of this memorandum is relevant for deciding this case. So
Hmm.
how it's a lengthy.
Page 14. Next sheet 2. Two-page memorandum.
Two-piece memorandum.
Hmm.
I'll leave you with that.
Yes.
So, middle it is.
Yes, yes.
Cabinet memorandum dated 13 May 2022. Subject relaxation of recruitment rules for special recruitment of health care workers. The cabinet has approved for creation of 390 new posts of doctor, nurses, and other paramedical staff, as well as filling up of existing vacancy on contingency basis in the wake of COVID-19 pandemic. Provide its decision taken on in meeting held on 30th March 2020, 1st June 2020, 23rd June 2020. While granting approval for creation of posts and filling up of those posts on an urgent basis, the cabinet had decided that the newly created posts should be filled up by the Health and Family Welfare Department on a temporary basis, and regular appointments shall be conducted through a special embassy recruitment drive. The details of this is not I'm coming to para 2. The newly created posts. You see, para 2 is also not relevant with the present case. This speaks about the promotion.
Hmm.
So I'm coming to para 3. Further, with a view to increase availability of healthcare workers for performing COVID-19 duties during the second week The government had also announced additional incentives for healthcare workers involved in COVID-19 duties. Give preference in the form of up to 25% of the total marks for the respective recruitment examination. This is important. 25% of total marks for the respective recruitment examination, depending on the length of COVID duties rendered to healthcare workers who have worked on COVID-19 duties in government or private COVID-19 facilities for at least 100 days. For appointment against regular government posts for any post recruited through NBC, NSSP, or Department Recruitment Board during the year 2021 and 2022, vice census. Paragraph 4 is very important. In consultation with Senior Department, it has now been decided to relax the recruitment rules as one-time measure for the special NBC recruitment drive for medical officers and junior dental surgeon to be recruited under the Nagaland Health Service Rule 6. This part, this sentence will be taken into consideration. The private respondent, they have considered, like, they have made a statement in the affidavit that the present post does not fall within the rules of the 6. But this cabinet memo is specifically says that to be recruited under the Nagaland Health Service Rule 2006 under the and also we come to page number 15. Your Worship, the top serial number 1, it speaks about the Nagaland Public Service Commission Regulation of 2008, which has no relevant with the case. And clause 2. The manner in which British or COVID-19 duties and work experience will be given as later on in the insurance subject. And also become the para 5. The relaxation with regard to the examination and interview scheme shall be given to those appointed on engagement basis by the department during the COVID pandemic, to those working on contract engagement basis prior to 2020, and to those which satisfy the condition as laid down in Department of Health and Family Welfare Solutions. So the remaining stuff is dealing with the person business. This cabinet memo, this was appended by the cabinet on in the same affidavit. So we come to page number 28.
Yes.
Page number 28. Minutes of cabinet meeting held on 25th May 2022.
May 2022.
That was taken up under agenda number 6. And the cabinet has approved for relaxation of recruitment rules for special recruitment of healthcare workers. The private respondent as well as state respondent have taken a stand in their affidavit that we have not challenged this approval. But Your Worship, this is that it is to challenge this approval is not important. That also says. Accordingly, Your Worship, in terms of the worship, before coming to that, worship, the private respondent, they have taken a stand in their affidavit that the Ministry of Health Services, they have issued certain guidelines to all the state government to give preference to the COVID-19 approach. Worship, the copy of the letter that we found it, the affidavit filed by the private respondent number 4 to 17. Worship, I'm relying on the affidavit filed by respondent number 3 to 18. The letter was not with me at the time of filing the petition.
3 to 18.
3 to 18. 4 to 18 also, they have also imposed a copy of.
Four to 12, there is one.
4 to 12 also just Worship.
Hmm.
In the affidavit also it's.
Hmm. 4 to 12 affidavit,
Page number should become the page number 18.
18.
18.
Government of India.
Yes, this communication was issued by the Ministry of Health and Family Welfare. No.
Mm.
Worship, may kindly take the note of this letter.
Yes.
This letter was issued on 3rd May 2021.
Mm.
Worship, in my further subsequent submission, this will be shipped to the 3rd May 2021. And Worship, the cabinet approval. The cabinet approval was issued on 25th May 2022, subsequent to this letter.
Cabinet meeting was 26/5.
Worship, the cabinet meeting was held on 25th May. The circular was issued on 26th May.
And this one is
This is
3rd
3rd
May.
May 2021. Prior to the sitting of the cabinet.
Wait, cabinet sitting was
25th May 2022.
26 May 2022.
Keep the private respondent number 19 to 101. In the affidavit, they have taken a stand that in view of the direction passed by the Honorable Supreme Court,
Hmm.
the ministry has issued this.
What Supreme Court direction?
Should give another next copy of the order, but in your affidavit, that is the statement.
Hmm.
That will be. As when my senior friend submit, you bring the.
Okay.
Lordship, in this letter, the only relevant portion is serial number 17. In this letter. Serial number 17.
Hmm.
The central government recommends to state union territory government to consider giving preference in regular government appointment of health provision through the respective public service commission and other recruitment bodies for those health personnel under this special scheme who complete a minimum of 100 days of COVID-related duty. Leadership in the cabinet memorandum also it speaks about whose first completed 100 days of
100
COVID.
days.
Exactly, that came in line with this.
Hmm. Yes.
Then I will come back to my affidavit.
Hmm.
Now to my repetition.
Hmm.
May kindly come to page number 126.
Yes.
In terms of the approval accorded by the state cabinet on 2022.
Hmm.
The Respondent Department has issued this notification
The special recruitment drive.
for special recruitment drive and to grant some relaxation to the COVID-19 approvals. Received this notification that is 2nd November 2022.
Hmm.
In the interest of public service and on the approval of the cabinet right number 22, the governor of Nagaland is pleased to notify the following posts to be recruited through a special recruitment drive as indicated below. Received, we are concerned with the serial number 1, medical officers, 98 posts. 96 posts.
96.
And then serial number 2. The special recruitment drive shall be conducted by the Nagaland Public Service Commission and the Nagaland Staff Selection Board. Number 3, the maximum age for eligibility is relaxed up to 45 years as one-time dispensation for officers, staffs serving under on contract engagement basis under NHN, NSC, and number four is relevant in terms of you were speaking about for relaxation of 25%.
Hmm.
The allocation of marks shall stand as indicated below. Written examination, that is 50%, so number B, weightage of COVID-19 is 25%. That means those employees who have served during the COVID-19 pandemic will be given a percentage of 25%, which is equal to 125 marks in the examination.
Hmm. Weightage for COVID-19 duty.
Yes.
Hmm. Hmm.
And serial number 6, page number 127.
Hmm.
The allocation of marks shall be applicable only to those officers staff who are serving contract engagement basis and contractual employment under NHAG, NHM, NSEC, etc., who had this. This is not important.
Officer source.
Accordingly, in terms of
5 minutes. Yes.
Yes. Worship, in terms of this notification dated second November 2022,
Hmm.
the department has submitted a requisition to the Nagaland Public Service Commission
Hmm.
to conduct a special recruitment drive.
Page 128.
Yeah, Worship, that I'm not referring to.
Hmm.
Worship, we can't get to the state government.
Hmm. Letter to peace. Yes.
We come to page number 29 in the state government.
Continue. Hmm.
It should be the letter dated 10 November 2022.
Hmm.
The notification was issued on 2nd November 2022.
Hmm.
Immediately after the issuance of notification, they submitted a requisition to the engagement. It should be a read.
Yes.
Subject notification number so and so regarding this. Madam, in inviting a reference to the subject cited above, in the Health and Family Welfare Department notification dated 2nd November 2022, proceed speaks about the notification second November. I am directed to state that the special recruitment drive proposed by the department is not in accordance with recruitment rules of the commission. The NBC declined to conduct the interview in terms of the relaxation framed by the state government in their notification dated 2nd November 2022. So the proposed special recruitment drive to be conducted through the NBC came to an end by this letter. And also we come to the next page in the state government. This is a process which they have initiated for conducting the present recruitment drive, which is under challenge. Page number 30. The commission has examined the file relating to conduct of the special recruitment drive for COVID-19 appointees in respect of Health and Family Welfare Department and convenes the decision of the commission that since the department has withdrawn the requisition, Roshit, you have already withdrawn the requisition also. A question on valid reason by Federal number 22, dated 9 July 2024. That was only last year. NBC has no comment issue on the proposed special recruitment drive for COVID-19 appointees to be conducted by the Health and Family Welfare Department, as the whole exercise is within the prerogative of the department government. So the cabinet approval, which was accorded on 25th May 2022, has become redundant in view of this. The state respondent as well as the private respondent have taken a stand in affidavit that the present rate petition is not maintainable since I have not challenged the cabinet approval of 2022. But the approval of the cabinet for special recruitment drive, which was accorded on 25th of May 2022, has become redundant because of these two letters issued by the Nagaland Public Service Commission. Worship, now we're coming to the main issue.
Mm.
Page number 142. Which is under challenge. Please do listen. Is a memorandum dated 1st August 2021.
Hmm.
Yeah, read, just
Yes.
only the two pages only.
Yes.
Subject: proposal for regularization of services of COVID-19 appointees through Department Screening Committee and relaxation of earlier approved procedure. We can take note of the word in relaxation of earlier approved procedure. All the earlier approved procedure is done, which was made according to us on 25th May 2022.
This cabinet memo is dated.
Which is 1st August 2021.
Hmm. Hmm. Proposal for regularization.
Proposal for regularization. You should make. This only just contents of 2 pages, so I'm not reading.
This is.
Sure, number 1. During the COVID-19 pandemic, the state government created 11 categories of posts totaling 329 posts of doctors, nurses, and paramedics. The posts were filled up on exigency basis with the condition that they will be subsequently regularized through a special recruitment drive to be conducted by MBC and NSSP. Number 2. However, this process of regulation had been delayed by various litigation involving dental doctors, nurses, Ayush, research scientists, etc. The court cases have since been cleared. In the case of the dental doctors, the High Court has directed that out of the 5 posts filled during the pandemic, 2 posts to be filled through MBC recruitment and the 3 posts created during the pandemic be filled through special recruitment drive. The department also faced some difficulties due to the absence of service rules of certain categories of staff, such as research scientists, petitioner, and item number 24, and other technicians. However, it is feel that absence of service rules should not be made an excuse for regularization, since the rules can be framed at a later stage. Number 3, the issue of special recruitment drive through MBC as accordingly approved was referred to MBC, and in course of discussion, the commission expressed that the view that it would not be appropriate for it to conduct exam of such nature. So, Rashid, the 2 MBC letter, which I've just read out, is confirmed by this statement. However, the commission has conveyed that the process of regularization of COVID-19 appointees as mandated by the state cabinet in the High Court is within the mandate of the department. A copy of the clearance of MBC is enclosed at an extra so to facilitate this clearance, the department has also withdrawn all requisition made to MBC and NSP for regularization of posts under special recruitment drive. Number 4. Out of the initial total of 329 posts, there are now 280 who are still in service. Since MBC has expressed difficulty in conducting the regularization exam, and since a commitment has been made by the department for subsequent regularization of the service at the time of appointment during the pandemic, the following are proposed for consideration of the cabinet. This is the proposal. Regularize the COVID-19 appointees through a departmental screening committee consisting of representatives from BNR, Law and Justice, Directorate of Health and Family Welfare, and subject expert for each category. This is being proposed because MBC has expressed an ability to conduct the exercise. So now we cannot trace back to the 2022 cabinet approval. By this memorandum also is crystal clear. The 280 posts of COVID-19 appointees also include regular vacancies. However, those were counted and taken into account for the need assessment to manage the pandemic, and were appointed along with the posts created during the pandemic. He also performed duty during the pandemic. Condonation of age beyond 45 years. Number 4, implementation of reservation. So this is not relevant with our case. Permission may be given the ship. Worship, this is not delimited. It is speaks about the services which does not covered by the service rule. Number 5. Approvals are sought from the cabinet for the above proposal as one-time measure to regularize the service of health workers who had risked their life in their performance of their duties during the COVID-19 pandemic. The respondent state as well as the private students are taking a shelter in this clause. And worship, this cabinet approval was approved by the state cabinet in its sittings held on 6 August 2024, which is unrecognized. The next section. Page 1. The undersigned is directed to forward here with an extract of the minutes of the cabinet meeting held on 6 August 2024 for time information in necessary action. Additional agenda number 3. Regularization of service of COVID-19 appointees through departmental screening committee in relaxation of earlier approval. Earlier, it was for special recruitment track through the Nagaland Public Service Commission. Now they have changed the nomenclature to through
Regularization.
departmental screening committee. So, the cabinet approval for special recruitment drive through MDC should not be taken into consideration. Now the issue only relates to departmental screening committee.
Regularization through departmental screening.
Yes, sir. Since the state as well as the private respondent, they have taken a stand in their affidavit. Their cases has to be covered to the special MDC committee. And Lordship, the next include letter. This is a letter communicated by the state respondent to the principal director in view of the approval accorded by the cabinet is sitting held on 6 August 2024. Confirming the approval of the cabinet. And Lordship, we come to page number 146.
Which one?
This is a letter calling upon the private respondent to appear before the departmental screening committee. Here, the present case is really concerned with the medical officers. So, when we come to page number 147, this is the list of the private respondents who were directed to appear before the departmental screening committee. As I submitted earlier, the name from serial number 1 to 15. Here, the contract appointees in the department during the year 2012 and 16. So, your case does not come within the purview of this cabinet approval to be considered along with the COVID-19 appointees. Those are the chosen ones in the department. More. On earlier occasion, they have approached this honorable by filing a writ petition. Proceed the copy of the order is next.
1 minute. In this list, they are at serial number 1 to
1 to 18.
15.
1 to 18.
18.
It's serial number 1 to 9. 1 to 9, they have approached this on earlier occasion, they have approached this honorable court by filing a writ petition to consider the case for declaration as in terms of the policy framed by the state government. The court judgment is at page, and the next at page number 154.
Here, respondents number 1 to 9. I
1
mean,
to 9. The writ petitioner in this, the BBC number, here the respondent number, just BBC number 70 of 2022. You were the petitioner.
WPC 70.
Then the other private respondent. Private respondent 4 to 12.
Did they approach the court praying for?
Praying for consideration of the case for regularization
Regularization.
in terms of the policy framed by the state government. That relief was not granted by the case honorable court. The rate petition was dismissed. He filed a review. The review was also dismissed. The order passed the review petition. They have annexed into your respective outfit. That is the facts. So, Rashmi, kindly come the provision of the source. May I take your worship to row 5, page 2.
Six. No, rule 5.
Classification and cadre of posts. The service shall consist of the following classes in grade of posts, carrying the scale of P in schedule 1. Worship, now we are concerned with the medical officers. Medical officers comes under junior grade, that is clause 4, under the same books.
Clause 6, I think. 5.
Or 6, I'm
Rule
sorry.
5, clause 6.
Junior grade, medical officers,
Yes.
junior specialist, junior dental surgeon. So, worship, the petitioner in item number 32. Her case is also covered by this rules.
Dental
She's
surgery.
serving as junior dental surgeon. May I take your worship to the method of recruitment? That is under rule 7. Method of recruitment. Recruitment to the service after the commencement of this rules shall be made by either of the following method. Basis, one, by direct recruitment in accordance with rule 8, by promotion in accordance with rule 13. Clause P is in. The respective quota reserved for direct recruitment and for promotion. The qualification in other condition required for promotion from lower grade to higher grade in the qualification required for direct recruitment shall be as specified in schedule 2. Essential qualification is described under rule 2, schedule 2.
Schedule 2.
Question become the page number 29. 20. Page number 20. At the bottom. Serial number 6. Junior grade. 100% by direct recruitment or to call it.
Yes. The post 100%.
The post shall be filled by direct recruitment. The minimum qualification for direct recruitment shall be NDPs or equivalent degree of a recognized university. All the petitioner possess the essential qualification. And as per rule 7, it says that the post has to be filled up through the Nagaland Public Service Commission. That is the provision of the relevant rules. If the state as well as the private respondent have taken a stand in their affidavit that at the time of issuing the initial advertisement, we were not qualified, except the petition number 1, 11, and 55. So we have no locus to justify the present. That is the ground which they are taking. As I've shown the lordship in the appointment order, you engage on contingency basis for a period of 12 months, subject to regularization through the Nagaland Public Service Commission. As on date, they are holding a post on contingency basis, not on regular basis. So the post held by them is open to request. So in support of that, a similar issue came up before this honorable, a division bench of this honorable court in the year 2006, which is reported in 2006 volume 3 till 236 in the case of Manipur.
Yes.
So I think you're also only the relevant portion.
Mm.
Also may come to para 4. Also may para 4 also in the right hand side. Also may read from the 13 lines.
Para 4.
Para 4. Para 4 in the right hand side from the 13 line.
Yes.
In any case, you should call it.
In
In
any
any
case.
According to the learned senior counsel, the candidates who appear on the selection held in 1999 cannot now be asked to appear with the fresh candidates after 7 years, as it will amount to treating the unequal as equal, hereby violating the fundamental rights guaranteed under Article 14 of the Constitution of India. In view of the fact that the candidates like the appellants who appeared in the selection made in 1999 cannot compete with fresh graduates in the selection and vacancy against 161 posts having occurred in the year 1991. The candidates who became qualified hereafter cannot be allowed to sit in the selection against those posts. The learned senior counsel therefore submits that at this a direction be issued to the state respondent to confine the selection for those 161 posts of graduate science and arts teachers to the candidates who were sponsored in the year 1991 by the employment exchange without allowing, this is important, without allowing the fresh graduate to compete with those candidates, including the appellant against those vacancies. That was the submission made by the appellant in the committee. Those are the findings of the appellant. Number page. Come to page number 12. Paragraph.
Para 12.
The contention of the learned senior counsel for the appellant that he being qualified in the year 1999 cannot be asked to appear in the selection with a fresh graduate and also fresh graduate and with fresh graduates and also fresh graduate who were not qualified in the year 1991 when the process of selection against those 161 posts was initiated. Also cannot be allowed to compete for selection against those 161 posts. And therefore, the respondent authorities be directed to fill up those 161 posts by making selection from among the 14,000 candidates who appeared in the selection list in the year 1991. Also cannot be accepted as admittedly the earlier selection process was cancelled by the government by taking a policy decision. Therefore, the posts available at that point of time, are also available for selection now. The person who have in the meantime qualified also have a fundamental right to seek public employment. And in the event the recruitment process of 161 posts are restricted to the person who qualified in the year 1991 only, that will amount to infringement of the fundamental rights of the candidates qualified hereafter, as will amount to depriving equal opportunity in public employment. Moreover, the appellants are seeking selection for appointment as graduate teacher of arts and science, who, if qualified, will be responsible for imparting. Should this reminding that? Not good. As I pointed out earlier, as on date, they are serving on contingency basis, not on regular basis, with the condition that your appointment was recognized through the Nagaland Public Service Commission. So the posts held by them are open to resignation. And the next round, the state as well as the private school have taken a standing affidavit by relaxing the provision of the 2006 rules.
Mm.
The present recruitment process has been initiated.
Mm.
Unless the role is amended, your condition is totally fine without.
Mm.
So I'm relying on the judgment passed in the year 1998. 1998, with SEC 469. This just has a one page judgment. Unless the rule is amended, as of date, the rule is not amended. You cannot take such a plea unless the rule is amended. Actually, this judgment was passed by a 3 judges bench,
Mm.
including the 10 chief justices of India.
Mm. Para?
Relying on part 3.
Mm.
The short point on which this appeal must succeed is that the tribunal failed into an error in taking the view that since the government had indicated its intention to amend the relevant rules, same as in the case,
Mm.
its action and proceedings on the assumption of such amendment would not be said to be irrational or arbitrary. And therefore, the constitutional order passed have to be upheld. That was the case before the next photo.
Mm.
In the present case also, you are saying that you have taken a stand that the special recruitment list and relaxation of the rules of 2006. Which is the findings of the ethics board. The relevant rules.
Mm.
The relevant rules, it is admitted, were framed under the proviso to Article 309 of the Constitution. These are statutory rules. Statutory rules cannot be overridden by executive orders or executive practice. That is the core issue which is involved in the present case. Merely because the government had taken a decision to amend the rules does not mean that the rules were obliterated. Till the rule is amended, which is important, the rule applies. In the present case, at no point of time you have amended the rule of 2006. So the ground, the contention of the private school state respondent in the evidence is probably best. The rule of 2006 still as it is not amended. The text procedural merely because the government had taken a decision to amend the rules does not mean that the rules were obliterated. Till the rule is amended, the rules as
Yes.
and Russia might be allowed to refer to another judgment, which says that no regularization is permissible in exercise of the power conferred under Article 162 of the Constitution, if the appointment has been made in contravention of the rules. I'm relying on 2007, volume 9 ECC 337. And Lordship, this judgment was passed by referring to an earlier judgment because it was passed in the year 2004. So I'm not placing the judgment of 2004. I'm relying only this 2007.
Mm.
The relevant portion is a para from paragraph. Rely on paragraph. Further, when the terms and conditions of the service of the employees are governed by the rules made under a statute or the proviso appended to Article 309 of the Constitution of India, then on the move and manner in which the recruitment would be given effect to, even no order under Article 162 of the Constitution of India can be made by way of alteration or amendment of the said rules. That is the low wages attracted in the present case. The rules of 2006 specs that the post of medical officer has to fill up through the Nagaland Public Service Commission. By deviating from the provision of the said rules, now they are taking the reports to fill up through the Department of Selection Committee, which is not permissible as per the law laid down by the district, as well as this. And we should be paragraph 13.
Hmm.
This aspect of the matter is covered by a decision of this court and so. But this is the judgment passed in the year 2004. The paragraph 15 of the sec 2004 judgment. No regularization is thus permissible in the exercise of the statutory power conferred under Article 162 of the Constitution if the appointment has been made in contravention of the statute rules. The state government cannot issue such a direction to fill up this 94 posts of medical officers by Department of Selection Committee. When the when the post of medical officer has to fill up under the rules of truth.
What about the differentiation made in Uma Devi between irregular and illegal?
So I'm coming to that one.
Uh,
2006 24. In this modifications, so I'm relying on three paragraphs. Here also it says when the post has to fill under the rules framed under Article 3, the state cannot deviate from it. We should become the paragraphs. The power of a state as an authority is more limited than that of a private employer, in as much as it is subjected to constitutional limitation and cannot be exercised arbitrarily. Article 309 of the Constitution gives the government the power to frame rules for the purpose of laying down the condition of service and recruitment of persons to be appointed to public services and posts in connection with the affairs of the union or any of the state. That article contemplates the drawing up of a procedure and rules to regulate the recruitment and regulate the service conditions of appointed to public posts. It is well acknowledged that because of this, the entire process of recruitment for service is controlled by detailed procedures, which specify the necessary qualification, the mode of appointment, etc. This is important. If the rules have been made under Article 309 of the Constitution, then the government cannot make appointment only in accordance. Then the government cannot make appointment only in accordance with. Then the government can make appointment only in accordance with this. If the rules are framed under Article 309. In the present case, also just rules. I mean, allowed to public the subsequent funding. The state is meant to be model employer. The Employment Exchange compulsory notification of vacancies in 1951 was enacted to ensure equal opportunity for employment seekers. Now this act may not oblige any employer to employ only those persons who have been sponsored by employment exchange It places an obligation on the employer to notify the vacancies that may arise in the various department and for filling up of those vacancies based on the procedure. Which is from the next sentence is one. Normally, studio rules are framed under the authority of law governing employment. If it is recognized that no government order, notification, or circular can be substituted for the studio rules framed under the authority of law. This is because following any other course would be disastrous in as much it will deprive the security of tenure and the rights of equality conferred on civil servant under the constitutional scheme. It may even amount to negating the accepted service jurisprudence. Therefore, therefore, when the studio rules are framed under Article 309 of the Constitution, which are exhaustive, the only fair means to adopt is to make appointment based on the rules so far. And motion may come again to para 11. Alright, in addition to the equality clause presented by Article 14 of the Constitution, Article 16 has specifically provided for equality of opportunity in matter of public employment. Buttressing these fundamental rights, Article 309 provides that, subject to the provision of the Constitution, acts of the legislature may regulate the recruitment and condition of service of persons appointed to public service imposed in connection with the affairs of union or of a state. In view of the interpretation placed on Article 12 of the Constitution by this court, obviously, those principles also govern the instrumentalities that come within the purview of Article 12 of the Constitution. With a view to make the procedure for selection fair, the Constitution by Article 315 has also created a Public Service Commission for the Union and the Public Service Commission for the state. Article 320 deals with the function of the Public Service Commission and mandates consultation with the Commission on all matters relating to method of recruitment to civil services and for civil posts in other related matters. As a part of the affirmative action recognized by Article 16 of the Constitution, Article 335 provides for special consideration and the matter of claims of the members of the scheduled caste and tribe for employment. The states that met acts rules or regulation for implementing the above constitutional guarantees, and any recruitment to the service in the state or in the union is governed by such act, rules, and regulation. The Constitution does not envisage any employment outside this constitutional scheme. The Constitution does not envisage any employment outside these constitutional schemes without following the requirement set down there. And lastly, I'm allowed to refer to para 43 or 43.
It is 43.
Thus, it is clear that adherence to the role of equality in public employment is a basic feature of our Constitution, and since the rule of law is the core of our condition, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirement of Article 14 with Article 16 of the Constitution. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competing among qualified person, the same will not confer any right on the appointee. This is what is affected in the present case. If it is a contractual appointment, the appointment comes to an end at the end of the contract. They are on contingency basis for a period of 12 months. If it were on engagement or appointment on daily wages or casual basis, the same would come to an end when it is discontinued. Similarly, a temporary employee would not claim to be met permanent on the expiry of his term of appointment. It is also to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the term of his appointment, he would not be entitled to be observed in regular service or made permanent merely on the strength of such continuous, which is similar to the present case. If the original appointment was not made by following a due process of selection as envisaged by the relevant rules, it is not open to the court to prevent regular recruitment at the instance of the employees whose period of employment has come to an end or a top employee who by the very nature of their appointment do not acquire any right. The High Court, acting under Article 226 of the Constitution, should not ordinarily issue direction for observation, regularization, or permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme. Should this a direction not made? Merely because an employee had continued under cover of an order of the court, which we have described as the his employment in the earlier part of the judgment, he will not be entitled to any right to be observed or made permanent in the service. In fact, in such cases, the High Court need not be justified in issuing interim direction, since after all, if ultimately the increase approaching it is found entitled to relief, it may be possible for it to mold the relief in such a manner that ultimately no prejudice will be caused to him. Whereas an interim direction to continue his employment would hold up the regular procedure for selection or impose on the state the burden of paying an employee who is really not prepared. The courts must be careful in ensuring that they do not interfere unduly with the economic arrangement of its sphere by the state or its responsibility, or they themselves the instruments to facilitate the bypassing of the constitutional and statutory mandates. Also, the question was made a query regarding the regular appointment.
Para 53.
53.
Mm,
That is a cutoff date.
yes.
As in 2006, who have completed 10 years of continuous service, he can be considered. The present case does not fall within the purview of paragraph 52.
Mm.
Otherwise,
Otherwise, they were appointed under sanction post.
you were appointed under sanction
Sanction-
post.
in
but
sanction
that
post.
condition, it's in continuous basis. For a period of 12 months, subject to reconsideration through the industry.
Under 53, the state governments have been given liberty to frame schemes for regularization.
In the present case,
Mm,
state government formulated this
mm,
for special development act in Kolkata to the Nagaland Resource Commission. Nagaland Public Service Commission declined the proposals submitted. to government, which is not under challenge by the Congress. By almost submission is the present petitioners got a fresh legal credits. You are qualified to compete for the post of medical officer. We're not asking for them. We're only prayer is the post should be filled as per the rule of 26. We're not asking for appointment. We're only prayers the post should be filled through them as per the rules of 26. Let's make this.
mm. Yes.
Yeah, please, your lordship.
Yes.
I'm agreeing for respondent number 19 to 23
19 to
and
23.
25 to 101. Those
25 to 101
19 to 23
and 25 to 101.
101 who were appointed to the advertisement of the COVID appointments.
during the COVID.
Because there are two categories.
Mm.
One, some who were appointed on contract and were included by the policy of 2024,
Mm.
which is at the challenge. And item number 19 to the respondent number 19 to 101
Mm.
are those who were appointed against the advertisement.
19 to 23 and 25 to 101.
Yes, and 24 is also appointed, but he's also similarly circumstanced, where my
Oh, okay, okay.
younger brother is appearing. So that distinction has to be kept, contract appointees and who were appointed
Those
to
who
the.
were appointed before COVID and then during COVID.
Yes. And another distinction is we are appointed through an advertisement,
Mm,
against an advertisement.
against me.
So we are not back to appointees. 19 to 101 our initial appointments, it is not back to appointment much. Now, before I make my submission, the-
1 minute, let me just sort out the papers. Yes.
I would like to sum up to my simple, humble understanding of the ground of submission by the counsel for the petitioner.
Mm.
Number one, he made a submission that he has got the longest standing
Mm.
to
To
find a
appear,
restriction because we have raised the issue of maintainability of the case. Secondly, his strong argument is based on the service rule that the proposed special recruitment test, departmental exam or whatever, is in clear violation of the service rule.
Mm.
And in view of the judgments of Kohima TV, the should be interfered with, and it is not permissible under the law.
Mm.
And another argument he was submitting was that since the department did not amend the service rule, there's by relying on the judgment of 1998, by Leonard Frame was making a submission that since there is no amendment of the service rule, unless and until the service rule is amended, it is not possible for the state government to take the decision as it is challenged. That is also another argument.
Mm.
And thirdly, in view of the letter of NPSC in the year 2022 expressing its inability to conduct the special recruitment drive, the submission of the counsel for the petitioner is that the cabinet decision of 2020 and 2022 has become redundant and it is not necessary for him to change. These are the broad
Yes.
legal issues which my learned friend has submitted, subjected to, of course, his right to reply after we are submission. My line of argument, broad case speaking, because it's going to be one of them.
Mm.
First, I'll be questioning the maintainability.
Mm.
Lordship may kindly appreciate how the post was created, how we were born. Through a cabinet decision of 2020, the state government had took a decision, cabinet took a decision to relax the rules and procedures. I will refer to the cabinet member to relax the rules and procedure for recruitment, regularization, and condonation of age. Three things. Recruitment of rules and procedures. Two,
Relaxation of the rules.
relaxation of rules and procedures. Dr. Mikhail, take note of it. It's twofold. Cabinet had decided to relax two things: relax the rules and procedure for recruitment. And for what purpose? For recruitment, for regularization, and for condonation of age. For three purposes, procedures and rules was relaxed by the cabinet of decision of 2020. Thereafter, posts were created. Now, creation of the post. Lordship, I'll satisfy with the Lordship before this honorable court. Before the learned single bench and division bench of this honorable court, the validity of the SRD was challenged by some fresh dental surgeries. The notification was challenged on the ground that all the 5 created vacancies by the SRT should be should be recruited to the Nagaland Public Service Commission in accordance with the rules. That was the prayer. The learned single bench as well as the division bench has upheld that since 3 posts was originally created for SRT out of 5 posts, that should be conducted by the special recruitment drive and through open competitive exam through NPSC. So in these two judgments, which I'll satisfy your lordship with due cause, has upheld the validity of the SRT. So when the validity of the SRT has been upheld by the division bench of this honorable court and the concurrent single bench of this honorable court, as a matter of judicial principle, there is no question. It is too late of the day to question the legal validity of the special recruitment drive. I'll come to that at the later stage. Also, lordship, by cabinet decision of 2022, he decided reaffirm the earlier cabinet decision of 2020 to say that rules and procedures will be relaxed, and the procedure was prescribed whereby the NBSC will conduct a special recruitment drive. That is the second cabinet decision. And then in 20, however, the NPSC expressed its inability in view of his unique position. And a letter was written in 2022 that we are not in a position to conduct this rule, but it is within the prerogative of the department. Thereafter, department sought further clarification, and NPSC sent another letter giving the clearance for departmental exam. NPC has written two letters.
Yes, yes.
Number one.
Second one, it said department can go ahead.
Yes, second one, it says department can go ahead. Accordingly, it was reprocessed back to square one, department reprocessed it, and then it was put up to the cabinet in 2024. And what the cabinet has done, cabinet, in view of what has transpired with the NBSC, the cabinet took a decision to relax the procedures, not the rules. Rule is already relaxed, lordship. In 2020 and 2022, rules were relaxed. So it is not necessary for the cabinet to relax the rules again. So the procedure, in view of the difficulties faced and the commitment given to us, department prayed for relaxation of the procedures, and in 2024, cabinet took a decision to relax the procedures only. Accordingly, the special accordingly it should be done departmentally. So, in view of that, lordship, we are taking a ground that the basic order, we are taking a ground that the three cabinet decisions should not be read in isolation. We should be read together. Because it is a continuous process.
But the NPSC expressed difficulty to conduct the special recruitment drive.
Yes.
Yes. So that is over.
So that captain, then we wrote to the NPS, the department wrote to the NPSC again. And NPSC give a clearance again that we cannot go ahead, but you can conduct the exam. Departmentally, it can be conducted. So these two letters have to be read together, not in isolation. I'll satisfy your lordship with the records. So, lordship, in 2024, from the cabinet record, minus it is very clear, cabinet only relaxed the earlier procedures. That is, instead of NPSC, now it will be conducted departmentally. Rules is already relaxed by cabinet decision of 2020 and 2022. So, lordship, when the basic orders, relaxation of the rules is not challenged, consequential order cannot be challenged. That is would be my line of argument. In fact, lordship, there is a judgment of the Supreme Court. In that particular case, the departmental promotees quota was regularized through cabinet. And people who are eligible for direct recruitment, they challenged the regularization, the decision of the cabinet to regularize their services. However, the apex court, the Honorable Supreme Court has held that since the cabinet decision to regularize the service has not been challenged, the appeal was rejected, and in view of that, the fact that the policy decision to regularize by the cabinet is not challenged, the Honorable Apex Court in Nuku's idea says, State of Assam has held that in view of that facts and circumstances, the judgment in Oma TV will not be applicable. Because basic orders and lordship, the judgment of the Honorable Supreme Court, when my learned friend is talking about it is redundant, so it is not necessary for the challenge. Whether it is redundant or not redundant, it is not for the petitioner to decide, it is for this Honorable Court to decide. That is the law. Accordingly, the Honorable Supreme Court has held, even if a person considers an order to be void or illegal, unless it is challenged and set aside by the competent authority, the efficacy of that order remains. And whether it is void or not void, whether it is redundant or not redundant, it is not for the petitioner or for the parties to decide, but for the competent authority to examine and decide. So, even presuming in not admitting the fact that it is redundant, it is presumed. Even then, the 2020 cabinet decision and 2022 cabinet decision by which rules were relaxed and has not been challenged. So, Lordship, on the issue of validity of this two cabinet decision, it is already it has attained its finality. It is beyond the purview of this Honorable Court because nobody is challenging it. So, Lordship, this case has to be examined in the light of the cabinet decision of 2020 and 2022, whether relaxation of the rules will cover and also another important factor. The post was created for special recruitment drive. Specifically in the creation, in the notification, it is specifically mentioned that post is created for special recruitment drive. It is not a general vacancy. Now, however, the creation of the post, because Lordship, it is very important for us.
But they were created, the order says it has to be through NPSC.
Lordship, I will satisfy your Lordship according.
Even if it's a special recruitment drive.
The question, even if it is special recruitment, on one in which context, on what context, whether it is NPSC, that means special recruitment drive to NPSC or regular NPSC. That has to be looked into. Because it says, because everything has to read together. So, Mother, the question is, because question of special recruitment drive, vacancy created for a special recruitment drive, not a general vacancy. There, the question of maintainability will come. Because for general vacancies, everyone will be eligible, no issue. But here, from day one, certain commitment, Lordship, it was a warlike situation. And in such situation, certain extraordinary decision was taken. So, under what context the post was created? Under what context the post was created? Under what circumstances the post was created? And Lordship, another important thing is some of the petitioners were eligible, but they feared their lives, so they refused to apply. And after everything become normal, they are turning back and challenging. Now we are also eligible.
Some of them were eligible during that time.
And the rest were students. And the rest of them were students. I'll be coming to that, but I'm making a general submission in the last 10 minutes, in which way I would like to make my submission for easier understanding.
May I please, my Lordship?
Yes,
Lordship,
yes.
I beg your Lordship indulgence. Lordship, item number 6.
This case may take.
Yes, your Lordship. If this matter can be listed on Wednesday, my Lord. I was supposed to place certain instruction, I have received it.
Item 6.
Yes, item 6. your
Item
Lordship.
6 is when
Wednesday, my Lord.
learned government advocate prays for listing the matter on Wednesday. List on Wednesday. Yes.
I'm
Then
deeply obliged.
Lordship, the item number 29 and 30 also, that's in the hearing.
29, 30, when?
We've taken up on Thursday, my lord.
29 and 30, on the prayer of the learned counsel for the petitioner, list on Thursday.
My lord, bless you, Lord.
The date.
Please, your Lordship, I beg to mention item number 19.
19.
Come up on Thursday, Lord.
19 also Thursday.
Lordship, in the meantime, interim may be continued.
Yes, interim order passed earlier shall continue till the next day. Yes, anything else?
Much obliged.
Yes.
Mr. Lordship,
Yes.
Lordship, I beg to mention hearing item 20. 24 and 25.
24 and 25 is
Really, they are pushing at least after 1 week.
24 and 25 after 1 week under prayer of the petitioner. Respondent,
AG.
and not opposed by the learned counsel for the respondent number. Just say for the accountant general. Is anything else? Yes,
Lordship,
Devika.
item 15 also, your lordship.
Item 15,
Lordship, actually, the
When?
petition wants to take up to date, but
it may not reach, it may not
Can
reach.
we take up one?
But just say pass over for the day then. Yes,
Lordship,
yes.
item 21. In this case,
Ah.
I've got my appointment. So the
Ah.
letter will become infrastructure.
Infractures 21. Oh, 21. It is stated, submitted by learned counsel for the petitioner that the matter has now become infractious. Stop. Accordingly, the petition is disposed of as being infractious. Yes. Is that all?
Yes, your lordship.
Yes.
Your lordship, I beg to mention item number 16.
16, yes.
Your lordship, responding 3, 4, and 5 are yet to file the counter affidavit. So I read the middle list of the.
Item 16. But the respondents are not here. It is stated by the learned counsel for the petitioner that the respondents, which respondents?
Respondent 3, 4, 5.
3, 4, and 5 are yet to file their counter affidavit. The learned counsel for the respondent is not present. However, list the matter after 2 weeks,
Yes,
2
your
weeks awaiting the affidavit of the respondents. Yes. Yes, yes.
Lordship, I beg to mention item number 28.
28.
Yes, Lordship.
Yes.
Lordship, my candidate fix this matter after a week.
After a week.
Yes, your lordship.
Where is the petitioner?
Yes,
Ah.
after 1 quarter.
Okay. Learned counsel, MS Nangali,
I
praying,
respond.
appearing for respondent number 5 has prayed for listing the matter after a week. It is, the prayer is not objected by the learned counsel for the petitioner, list the matter after 1 week.
Much.
Pledge, Lord.